Good evening and welcome to the Newshour Agenda. I'm Madhavdas Gopalkrishnan. Now, what's being seen as a major victory for the Hindu side seeking a judicial review of a law that they insist takes away their right to worship. Now, the Supreme Court has today agreed to review the 1991 Places of Worship Act. The court has set the ball rolling on review of a law that protects the identity and character of religious places as on 15th August 1947. The centre has been asked to file a response within 2 weeks. This ruling came on a slew of petitions filed against the Act, contending that it has illegally fixed a retrospective cut-off date, that is August 15, 1947, illegally barring Hindus, Jains, Buddhists and Sikhs from approaching courts to reclaim, quote-unquote, their places of worship, which they claim were invaded and encroached upon by fundamentalist barbaric invaders. Now, they say that the main objective of these petitions is to set right a historical wrong. Jamaat-e-Ulema-e-Hind has countered these arguments, suggesting that a review will spark fears among Muslims and open the floodgates of litigations, as there are countless mosques in the country that the Hindu side may stake claim to.
If at all this becomes a stumbling block, it should be the 15th of August 1947. Say that either the court strikes it down or the parliament amends this law.
देखिए, सुप्रीम कोर्ट का फैसला पहले भी था और आज सुप्रीम कोर्ट ने अगर इसे एक्सेप्ट किया है तो ये बहुत ही अफसोस की बात है। 1991 में एक क़ज़िये को, एक कंट्रोवर्सी को ख़त्म करने के लिए जो बहुत तारीख़ी थी और जिसके लिए बहुत ज़रूरत शायद उस वक्त महसूस की जा रही थी, सुप्रीम कोर्ट ने फैसला किया। और उसके साथ साथ ये भी एक सुप्रीम कोर्ट का आइडिया था कि आगे इस तरह के रोज़ कोई इश्यूज़ ना उठें और देश का वातावरण ख़राब ना हो। आज देश का वातावरण इस वजह से बहुत ज़्यादा ख़राब हो रहा है कि जगह जगह पर याचिकाएं जो है वो लगाई जा रही हैं छोटी कोर्ट्स के अंदर, और छोटी कोर्ट्स के अंदर बाकायदा उनकी सुनवाई भी शुरू हो जाती है। और सुप्रीम कोर्ट को अब इसका संज्ञान लेकर के और सही फैसला करने की ज़रूरत है।
The court's readiness to test the law is significant, considering the recent happenings in courts in Delhi, Varanasi, Mathura and the Supreme Court, which test the protective grip and probe the boundaries of the Places of Worship Act 1991.
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
And for more on this, let's go across to our guest. Joining us live, we have with us Vishnu Jain, lawyer. Ashwani Upadhyay is a lawyer as well as, of course, a member of the BJP and also happens to be one of the petitioners in this case. With us as well is Tehseen, Poonavala, political analyst. Advocate Shahid Ali is a president of the United Muslims Front. Let me first and foremost begin with Advocate Shahid Ali. Advocate Shahid Ali, we had seen what the Jamaat had said in its petition, and today's order of the Supreme Court at some level or the other is being seen as a setback, because they had specifically asked that even notice should not be issued, and the court has clearly not listened to that plea of theirs.
Even the notices should not be issued, because the question of the validity of Worship Act 1991 was dealt with by Honorable Supreme Court while the judgment in the dispute was passed by Honorable Supreme Court. And may I remind you the words of Honorable Supreme Court. Honorable Supreme Court had categorically stated and held in that judgment that the historical wrongs or rights cannot be appreciated at this stage by the people of today's world and the courts which have been working today's era. So the question of or the challenge to Worship Act 1991 is out of way, because there is already judgment of Honorable Supreme Court to that effect.
Sir, are you challenging the wisdom of the bench today in today's order by making such a statement?
No, this is not the question of wisdom. This is, I am saying this is the submission. This is the submission, and submissions are absolutely right. So everyone has right to make
held them wrong, sir.
Honorable Court.
How can they be right if the court has ruled otherwise?
Honorable Court, Honorable Court has not passed any judgment so far. This is the first and foremost submission. Therefore, we have all rights. The Jamaat has all rights to make submission.
No, you can make a submission, but that submission, was it good in law law or not is what the court has to decide. Let me quickly bring in Vishnu Jain on that. Vishnu Jain, there was an argument.
This is
okay. You made your point. Shahid Ali, let's get a counter. You made your point. Let's get a counter. Vishnu Jain is also with us. Vishnu Jain, the argument coming here from Mr. Shahid Ali appears to be that we were basing our arguments on what the court said earlier in the 90s, and therefore, in fact, at the same time, he says it's a correct argument to make. But the correctness of that argument can only be evaluated from what the bench ultimately decides. Your response to Mr. Shahid Ali?
See, Madhav, you are exactly right, and let me tell Mr. Shahid that so far as the validity of Places of Worship Act 1991 is concerned, that was not an issue before the Ram Mandir case. Because if you remember, there were 5 civil suits which travelled from Allahabad High Court to Supreme Court in civil appeal. And the Supreme Court has delivered its judgment on 9th November on those 5 civil suits. There was no challenge to the constitutional validity of Places of Worship Act 1991. So therefore, this is first time the Supreme Court is going to examine the constitutional validity of Places of Worship Act 1991. That is point number 1. Point number 2, my friend Mr. Shahid Ali said that Ram Mandir judgment has said that historical wrongs cannot be remedied. That is absolutely wrong. In Ram Mandir's case, the Supreme Court has said that historical wrongs can be rectified by the sovereign if it is recognized by the sovereign. And let me tell you, in today's constitutional era and today's constitutional setup, judiciary is exercising one of the sovereign functions. Therefore, our plea is that so far as Kashi is concerned, Mathura is concerned, Bhojshala is concerned, we have rights to approach court of law, we have right to file suits, and we have to see, we have to tell the court that see, in this particular property, the character of this property is of a Hindu religious character, and therefore this character is tried to be amended or changed, which is in violation of the Hindu basic principles and tenets as written by P.V. Karne as well as B.K. Mukherjee's Hindu law. So therefore that has to be examined. Now what my learned friend is arguing is that you can't even go to the court.
Okay, we're going to come to that. We're going to come to that particular point, and let me bring in Tehseen on this. Tehseen, I'm just reading out from the petition, and I'm just going to get in your response to this. It says, and I'm just quoting from it, it is submitted that even issuance of notice in the present matter will create fear in the minds of Muslim community with regards to their places of worship, especially in the aftermath of Ayodhya dispute, and will destroy the secular fabric of the nation. Issuing notice, Tehseen, will destroy the secular fabric of the nation. Isn't this just a judicial process that everyone has to respect? Can you just link it to the nation's secular fabric? Tehseen.
Good evening, Madhav. Thank you so much for having me on the show. And we've got 2 wonderful advocates in Ashwani Upadhyay ji and Vishnu Jain ji, both on the opposite side, but I really respect them. But Vishnu Jain ji is making one slight error. It's not only in the Ram Janma Bhoomi dispute judgment, like Shahid Ali rightly said, that the Honorable Supreme Court went into the Places of Worship Act. It's also the 1994 Constitutional Bench has gone into it in the M. Ismail Faruqi judgment. And though that was, again, in a different context, the bench has gone very stringently into that. Yeah, you're right, Vishnu Bhai. So it's already gone twice before that. So Vishnu Bhai raised a point. I'll come to that later on because you said we'll go to that later on. But here's the first part about it. In both these issues and the way the honorable courts have come down in both the Ram Janma Bhoomi and in the M. Ismail Faruqi issue, it's made it abundantly clear that the Places of Worship Act is a part of the basic structure of our constitution. Now, now you can say, okay, Ashwini Bhai or Vishnu Jain Bhai can challenge the basic structure of our constitution, say, oh look, secularism shouldn't be there, socialism shouldn't be there, or liberty should be there, whatever, fine. And the court may show notice. Will that act? It won't act because the court has already made its position clear. So all the best to them. I wish them luck. But here's a larger point. When you say that there is no judicial review, which is what Ashwini Bhai's petition comes to and Vishnu Bhai referred to it right now, it will not happen, and I'm telling you this in your record, because the courts will come down that something that's a basic structure of the constitution cannot be tampered even if the sovereign, in this case the government, has a 500 plus MPs in parliament, or the Supreme Court constitutional bench of 11 judges sit on it and say we need to change it. Because when you open these floodgates, tomorrow the entire constitution can be changed. The basic structure of our constitution cannot be changed.
Okay, the basic structure of the constitution cannot be changed, Ashwini Upadhyay. That's the argument coming in from Tehseen, Poonavala. But if I'm not mistaken, your petition talks about how this position or this particular law also violates several articles of the constitution. So how do you reconcile between these two aspects of the basic structure being violated is the argument of the other side, whereas you are arguing that several articles of the constitution are being violated by the Places of Worship Act?
The question is, we are governed by the constitution, we are governed by the rule of law, we have a democracy, and in democracy every dispute must be resolved through the court, not through the bhid tantra, not through the lathi danda, not on the streets. That's why I'm saying that this act totally against the rule of law. It is promoting the bhid tantra. It is restricting, it is destroying the democratic system. It is taking away the right to religion guaranteed under Article 25. It is taking away the right to culture guaranteed under Article 29. It is taking away the right to justice guaranteed under Article 19. It is taking away the rule of law guaranteed under Article 14. It is discriminating between Ram and Krishna, both of incarnation of Lord Vishnu, violation of Article 15. That's why I'm saying this act is totally, it's a black law. It's totally against the basic structure of the constitution. And my friends are saying that Supreme Court, please remember, the Supreme Court, Justice Bobde was part of the judgment, Ayodhya judgment, and Justice Bobde led bench issued notice in this matter. So he was well aware about the judgment, Ayodhya judgment, because he was the second most senior judge in the Ayodhya case, and he issued the notice in this matter. That's why I'm saying that please wait 1 or 2 months more, but I'm sure that this black law will go.
No, but Ashwini Upadhyay,
Hindu, Jain,
Ashwini Upadhyay, I want to just come in. Tehseen, all right, okay, Tehseen, come in. Okay, your quick response.
Ashwini ji, you know, I have a lot of respect for you, but I humbly submit that this law actually upholds Article 25, actually upholds Article 14, actually upholds Article 19, and let me explain to you why. Why is the petition? Please, may I please make my submission and you
okay, let him make his point. You can respond to him.
Yeah. Please respond to what I'm saying. If today, and you're saying, for example, in Kashi, Mathura, Jain Bhai is also saying that look, we need to open up these cases. Fair. Article 25 you are citing. But let's say some Jain citizen comes or some Buddhist citizen comes and says, look, there was a mosque or a temple constructed in the 8th century, which shouldn't have been constructed. How back in history are you going when you clearly concede that before 1947 we were not a democracy, before 1950 we were not a constitutional democracy? So how far are you going to go and how many cases are you going to open? Is it only related to Kashi, Mathura? Now if you're saying it's only related to Kashi, Mathura, why should my Jain citizens not get justice? Buddhist citizens not get justice? Or for example, a Muslim citizen hypothetically not get justice if they have a claim? So this actually violates Article 14, 25.
I'm going to allow that question. Ashwini Upadhyay, respond to that please.
Thank you, Sajad Bhai, for taking care of the concern of the Jains and Buddhists. Thank you.
You've got the wrong Poonavala, Ashwini Upadhyay. That's Tehseen Poonavala.
Okay. So, please appreciate, every constitution is made for their country. The Constitution of India protects Indian religion, Indian tradition, Indian culture. It protects our dharma, it protects the culture. So the issue is this: if something had been done during the Mughal era or British era, this is not the duty of the government to legalize the illegal act of the barbaric invader. It is duty of the government to correct the historical wrongs. This is the duty. What happened by enacting this law? The government, in fact, that was the Congress government, and my Tehseen Bhai is very close relative of the Rahul Gandhi also. My Tehseen is the brother-in-law of the Rahul Gandhi, so he knows what happened in 1991. This act was enacted only for the Muslim appeasement, nothing else. I am saying again and again.
No,
please,
but you're not answering his question. Ashwani Upadhyay, he's asking a fair question. He's saying that Ashwani Upadhyay, he is saying that you may do whatever in relation to the invaders, those who you believe are invaders. But if this is going to be, every historical wrong being undone, then what about the Jain temples? And there are examples of that where Hindu temples were built over them. What happens to those cases? That's a pointed question he's asking you. Please respond to that specific point. How far are we going to go back? It's not a factual question. It's just imaginary question. Not a single Jain came to the Supreme Court to oppose the places of in support of the places of. Okay, so you're going to wait till they. So you're going to wait till their petition. Okay, you're going to wait till their petition. But Vishnu's hand is going up.
Vishnu is the Vishnu.
Yeah, let Vishnu respond. Vishnu's hand is going up.
Vishnu is the real Jain.
Okay. Sir, we are nobody to give certificates to anyone. Let Vishnu respond. His hand is going up, so I want him to come in on this. Vishnu, please respond to that specific point made by Tehseen.
And we are all together.
Can I respond?
Okay. Vishnu first.
I'll respond to Tehseen Bhai. Tehseen Bhai said that how back we'll go to history. Now the point is this, that if this legal principle is followed, that if there was a temple, I am saying temple, mosque, Jain temple, Buddhist temple, if there was a temple existing in the past and there is a proof and documentary proof and evidence that that temple, Jain temple, mosque, Buddhist temple has been destroyed by any invader, it has to be restored. Because let me tell you, Tehseen Bhai, kindly read today please. I know that you are a very well-read person, but I'll again pursue you to read para 116 and 117 of the judgment of Ram Janmabhoomi. What does it say? That the vow to establish a temple is amar and amit. जो मंदिर बनाने का संकल्प होता है वो अमर होता है, अमिट होता है. It remains till the end of the time, and that's the Muslim law also. That once a property is a waqf property, it always remains waqf property. So at the same point of time, Tehseen Bhai, kindly see that discrimination and the dichotomy. The same government enacts the Places of Worship Act 1991 and enacts the Waqf Act 1995. Under the Waqf Act, you have power under section 40 to declare any property as waqf property. Today, Waqf has 8 lakh properties in the country, and so many mosques have been declared as waqf property. So you have the right to declare any property as waqf property. Against that, a person can go to Waqf Tribunal, then to High Court, then to Supreme Court, and for us there are no legal remedies.
Okay, quick response. No remedies being given. There are multiple remedies for the other side. We have no legal remedies. That's the argument of Vishnu Jain. Please respond to that.
But if Vishnu Bhai really feels that, he should challenge the Waqf Act. You cannot challenge another act because he feels the Waqf Act is anti-constitutional or ultra-wise of the Constitution. But I wish you the best of luck in that. And I wish you the best of luck in that.
Okay. Gentlemen, calm down, calm down. I'm going to come to you. I'm coming to all one by one. Yeah.
I wish you both lot of luck in that. But we cannot challenge this act. No, for that, my brother.
Thank you.
Okay. Okay, let me bring in Advocate Shahid Ali. Advocate Shahid Ali, one of the petitioners, I'm going to quickly read out one aspect from this petition, because one of the petitioners says that for a legislation that shuts the doors of justice to affected communities, and they're talking about the Places of Worship Act, and parties, it was debated only in 3 dates, that is 23/8/1991, 9/9/1991 and 10/9/1991. The bill was passed on the last of the set dates. Many feel that this is a act that was passed in an undemocratic manner and also shuts the door on justice for the affected parties. That's the plea of the petitioners, or at least one of the petitioners. So if there is some kind of grievance as far as this particular act is concerned, can the doors of justice be shut to it? Particularly because it's retrospective in nature.
How bad and surprising is this? How bad and surprising is this? In 1991, a particular act was passed after having a lot of debates in Parliament. BJP had an opportunity to oppose that. They made submissions. Please go through the speeches made in the Parliament. Please go through the debate made in the Parliament. And all MPs of BJP, what they said, please leave the issue of Babri Masjid out of purview of this act. And we have no problem if the act is passed as regards the other properties, as regards the other mosques and mandirs and all. So this was, please go through the debates. I request all panelists as well. Please go through the debates. And the main crux of the debate was on behalf of the BJP that please leave the Babri Masjid issue out of the purview of this act. And we have no problem if the act is passed. And moreover, sir, please allow me to speak. Please allow me to speak.
Make your point. Make your point quickly.
Since 1991, now we're in 2002. For the first time, the challenge is being made that we were not heard or the act was passed in hurry.
Okay.
Section 7 of the act says that this act will be having the overriding.
I want Ashwani Upadhyay to respond to that. Ashwani Upadhyay, the BJP had a different position then and has a different position now. That's the plea of Mr. Shahid Ali. That's the argument coming in from him. Please respond. You made your point, sir. Let him respond now. Ashwani Upadhyay.
Presently I am not an official spokesperson for BJP, but I would like to correct the fact. Mr. Arun Jaitley vehemently opposed this bill in Rajya Sabha. Ms. Uma Bharti opposed in Lok Sabha. Just read there, listen here, it's available on Google also. Please listen both Arun Jaitley and Uma Bharti. They both opposed and they boycotted. And even Jaitley said, you are passing this bill but it will not pass the Supreme Court. Jaitley said in 1991, he said if this bill will be challenged in the Supreme Court, it will not pass the test of constitutionality.
But let me ask you, Ashwani Upadhyay, we're almost out of time, but let me ask you one pertinent question. Let me ask you one simple pertinent question. That if that is the position and the stated position of the BJP, then what prevents the BJP, which has been power for 8 years now in the central government, from bringing in a bill to A, repeal the Places of Worship Act and bring in a new act? If that is indeed the position of the BJP, what prevents them from taking action within Parliament?
I don't know. I don't know because presently I am not an official spokesperson, so I cannot comment on this issue, what the prevent BJP. But I am very firm because government has not filed its response since last 2 years. We filed petition in 2020. It's more than 2 years. Government has not filed a counter. It means maunam swikar lakshadam. Silence is acceptance. Government admit it that our grounds are valid, our prayer is valid, and this act is unconstitutional. Government admits.
So the silence of the government is an acceptance of a plea. That's the argument of Ashwani Upadhyay. What will happen in 2 weeks?
Divorce,
completely out of time.
As well.
Completely out of time, Mr. Shahid Ali. I'd like to thank all of you for joining us. Mr. Shahid Ali as well as Vishnu Jain, Ashwani Upadhyay, Tehseen, Poonavala. The government obviously now all eyes will be on what it tells the Supreme Court because 2 weeks have been given to the government to respond on this, and given the fact that it is the Chief Justice's bench that's looking into this matter, will be very interesting to see what happens in a fortnight from now. Thank you so much, gentlemen, for joining us on the News Hour this evening.